Hello guys, welcome back after a long time. I know we've been missing in action, but I'm really sorry for it. We had a couple of technical glitches and we had to update the software. Long story short, we're back in business and we're gonna be sticking with the once a week schedule. And without further delay, let's just get into the video of today. Today we're going to be talking about reforms in criminal law. Let me just start by saying that this video is not exhaustive. We're just going to discuss a couple of points and it's going to get the debate started and get the conversation flowing, and it might help you if you are preparing for judicial exams, for essays or short notes. It might help you for college projects, or it might just help you for general knowledge in the law aspect, and it might help you with vivas, interviews. So let's just start the video. Most of these suggestions were actually recommended by the Malimat Committee on Criminal Reforms, which presented its final report to then Deputy Prime Minister Shri L.K. Advani in 2003. And let's just say we're still struggling with these issues, so they're still very much on the plate. The first issue would be regarding the system that we follow when it comes to criminal justice, that is the adversarial system. We examined the inquisitorial system, which is followed in a couple of continental countries like France, Germany, and some others, and there are certain good features which have been recommended time and again by experts that we should also adopt. This includes the duty of the court to search the truth and also to assign a very proactive role to the judges, to give directions to the investigating officers and prosecuting agencies in matter of investigation and leading evidence, with the object of seeking truth and focusing on just the victims. Now, we also have certain powers to judges and the way judges can interact with the victim or with the prosecution. We have provisions under Section 311 of the Criminal Procedure Code, Section 165 of the Indian Evidence Code, and similarly corresponding sections in the Code of Civil Procedure as well, which give some powers to the judges to interfere and to make questions and make inquiries and to order production of documents. All of these are there, but it's still lacking. The main system that we follow is the adversarial system, which inherently, by definition, requires for the judge to be a silent spectator. And many experts actually recommend that if the judges were more involved in the cases and gave clear-cut directions to the prosecution agencies and to the investigating officers, that it would lead to a much faster and more efficient way of justice. So that is the first recommendation. What do you guys think about this? The second recommendation is regarding the right to silence given under Article 20, Clause 3 of the Constitution of India, which says that no person accused of any offence shall be compelled to be a witness against himself. But a lot of experts actually believe that by having this clause, we are letting go of a very good source of information, that is the accused himself, and believe that there should be some way of tapping into this excellent source of information, which is the accused, without any duress or any illegal means. And that is what has been recommended by a lot of expert committees. Moving on to the next recommendation. Separating police from investigation, which is basically means separating the policing functions from the investigating functions. The machinery of criminal justice system is put into gear when the offences is registered and when they are investigated. A prompt and quality investigation is therefore the foundation of an effective criminal justice system. Right now, the police are employed to perform multifarious duties, and quite often the important work of investigation gets put on the back burner. A separate wing of investigation with a clear mandate that it is accountable only to the rule of law is the need of the day. Such investigators would focus solely on investigations and not policing, and should be trained in advanced technology, knowledge of the changing economy, new dynamics of social engineering, efficacy, use of modern forensics. The basic idea being delegation and compartmentalization of duties. If there are separate wings which are supposed to do different duties, it would be more efficient and the criminal justice system could work much better and the police would be less burdened. That is the recommendation, and moving on to the next point. The next recommendation is regarding witness protection and stronger perjury laws. The prosecution mainly relies on oral evidence of witnesses for proving the case against the accused. Unfortunately, there is no dearth of witnesses who come to the courts and give false evidence with impunity. Many witnesses give false evidence either because of the inducement or because of threats to him or his family members. For this, it is essential that there must be a strong witness protection program and stronger laws for any such witnesses who are caught lying. We have heard of many such cases in which the witnesses turned hostile, even though there is no such term as hostile in any of the laws, but we call it hostile witnesses when a witness goes against his prior version that he gave to the police. And the police version that he gave is recorded under Section 161 of the Code of Criminal Procedure. And Section 162 of the Code of Criminal Procedure says that they can't be used for any ways other than the ones which are given in 162, hence restricting the use of these statements. Thus, it makes it very easier for these witnesses to retract statements later on unless they've been recorded by a magistrate, which sometimes happen and sometimes does not happen. The point being that there is not enough a stronger witness protection system, and witnesses do come under effect. And even if it were you and me and our families were under threat, what would we do? What would we decide? Hence, it's not always the witnesses who are wrong, but sometimes just the entire system, which requires a stronger system of witness protection. That is our recommendation. Moving on to the next point. Clear sentencing policy. Right now, there's a lot of discretion as to what punishment to give a person who has been declared as guilty. Even in high courts and Supreme Court, since the judges keep changing, there is no uniformity as to what punishment should be given. For example, recently highlighted in the Uphaar tragedy case, where the unsins were not even given any additional jail term and fined a paltry sum of Rs 60 crores. We feel that there must be a uniform sentencing policy which lays down how much punishment for each offence and what could be the mitigating or aggravating circumstance so as to avoid having too much discretion in the hands of the court. And that could be a good thing and that could be a bad thing. If there is some sort of uniformity, it would create more of a deterrence in the mind of the accused. That is our recommendation. Now, hope these points help you in preparing for any exam that you're about to write, and if you're a layperson, then we hope this gives you a rough idea on what steps can be made to improve the criminal justice system in India. All the best and thank you for watching.